Hello, everyone. This is Samantha from the law offices of Samantha Wolfe. And at our office, we like to do monthly virtual seminars. So we've been thinking of new interesting ideas for everyone to be able to have for their monthly virtual seminars. And one of the things that we're going to try to do over the next couple of months is make shorter videos that answer some commonly asked questions that clients may have. So I wanted to kick off that series of virtual seminars. We are located at 20 East 6th Street in Suite 206 in Waynesboro, PA. And you can reach us at 717-655-2676. And we do our consultations. So if anything you hear today, or if you check out any other videos on our YouTube channel, you have questions or concerns, you can always reach out to our office. So today's topic, I wanted to discuss the estate administration process when we have a spouse that passes away, but we have a surviving spouse. So for example, if we have a husband and wife and husband passes away, I just wanted to talk a little bit about what does the surviving spouse or the wife need to do in that situation? Because a lot of times we get families that call right after someone passes away, and obviously they're emotional, there's a lot going on, and they're really worried about what they need to do to administer husband's estate. So I thought that it might be helpful for me to explain when you have to administer an estate. So the important thing to know that in Pennsylvania, most of the clients that we deal with, they do have a will. And so it helps direct where assets go when someone passes away. What we have to remember is that certain assets are titled so that they actually will not pass through the will, which is a good thing. If it doesn't pass through the will, it means that we do avoid the probate process. So the probate process is the process by which we get the executor appointed so that they have legal authority to be able to distribute assets according to what the will says. If somebody doesn't have a will, we still have to go through the probate process. It just means that we have to use Pennsylvania law to distribute assets as opposed to distributing them according to the will. So most of the clients that we meet with, they do typically have a will, and each spouse has a will, husband has a will, wife has a will. And one of the first things that I like to talk to clients about is the fact that a will does not govern certain assets because they're considered non-probate assets, which means that they will not pass according to the will. For example, retirement accounts. If you have an IRA, a Roth IRA, a 401k, those assets that you are permitted to designate a beneficiary. And if you designate a beneficiary, it doesn't go according to the will. So if we have a situation where we have a husband and wife and they have IRAs, maybe they have a life insurance policy, maybe they have a house, but it has both spouses' name on the deed. It's in husband and wife's name together jointly. They might have joint bank accounts, checking, savings, investment accounts, but both spouse's name is on it. They're jointly owned. Or if they're not jointly owned, maybe they have a beneficiary designation like we talked about with the IRA. If we have a jointly owned asset, meaning that it's two people together, husband and wife, if we have a jointly owned asset or we have an asset that has a beneficiary designation, none of those pass through probate, which means that the will or Pennsylvania law, as far as if you don't have a will, is not going to govern that. The beneficiary designation governs, or if it's a joint ownership, when one owner dies, title automatically vests in the joint owner. So if we have a husband and wife and they have a house, they have bank accounts, they have retirement, they have life insurance, they have annuities. The annuities, the life insurance policy, and the retirement accounts all have beneficiary designations that are the wife or the surviving spouse. Additionally, if their house and all of their bank accounts are jointly owned, then what happens is when the first spouse dies, everything automatically goes to the surviving spouse. Pennsylvania does have an inheritance tax, but the good news is that when one spouse dies, if everything pays to the surviving spouse, the rate of tax for a spouse is zero. So there would be no inheritance tax. So the good news is if everything passes to the spouse, 0% tax. If everything is jointly owned between husband and wife or is an asset that has a beneficiary designation, then that automatically goes to either the joint owner or to the designated beneficiary. Additionally, if you have a trust also avoids the probate process. So if the trust document says that upon someone's death, maybe it's going in trust to the spouse, or maybe it's a joint trust that just says that nothing happens until the second spouse dies. The good news is that we may not have to do anything when the first spouse dies. We may not have to file a tax return. We may not need to probate at all or administer an estate at all. Instead, what happens is title vests 100% in the surviving spouse. Now, what that means is that if we're talking about real estate, the question that I get a lot is, does the surviving spouse need to redo the deed, taking the deceased spouse's name off? And the answer to that is no, they do not. What will happen is if when the second spouse dies, if the executor wants to sell the property or convey the property, they will just reference the date of death of the first spouse and explain that title vested entirely in the surviving spouse, and then they'll put the date of death for the surviving spouse. That will give them the ability as the executor to either convey it according to the will, or if they want to sell it, they can sell it and distribute the sale proceeds. So first thing to know, I'm going to try to give us some bullet points because it's easier. First thing to know is that if you have a beneficiary designation and things are jointly owned between husband and wife, there may not be anything that needs to be done. You don't have to file an inheritance tax return. You don't have to probate the estate. Second thing to know is that if assets are jointly owned and it's real estate, you don't have to do a new deed between husband and wife. Okay, so no new deed is needed to be done when the first spouse dies. If it's bank accounts, we typically recommend that you leave the deceased spouse's name on, usually for about 6 months in case any checks come payable to the deceased spouse. But then once that time period is passed, we do recommend that you do go into the bank with a death certificate and take the deceased spouse's name off the account. But I would wait 6 months, okay? But just know you don't have to do a new deed. We don't have to file an inheritance tax return, and we don't have to probate the estate in the example that I'm giving. If, for example, we have a client where maybe accounts were held separately, maybe husband and wife had separate accounts and they did not have a beneficiary designation, then we might have to probate. So one of the most important things you can do as part of your estate planning is to go through your assets and confirm how those assets are owned and whether or not you have a beneficiary designation on them. That can save you a lot of time and a lot of effort. We are administering an estate recently where the house was titled in just one spouse's name. And that's a big deal because it means that we have to probate the deceased spouse's estate in order to be able to transfer it to the surviving spouse. So even though the will says everything goes to the surviving spouse, had we just put the surviving spouse's name on the deed, we wouldn't have had to probate. Now, the reason why this client didn't do it as part of their estate plan is because they actually did not do an estate plan at all. So they never met with an attorney while they were living. So there wouldn't have been a way for them to have known that they needed to add their spouse onto the deed. But just remember, joint ownership between husband and wife doesn't make it a lot easier. The other asset that a lot of people have out there that they might not realize is not jointly owned would be savings bonds. We've had a few circumstances in which one spouse dies and there are savings bonds that were just in the deceased spouse's name, so the surviving spouse in order to get access to those funds. Another question that clients ask has to do with vehicles because they want to know, do they need to have both spouses' name on the vehicle? And the good news in Pennsylvania is that if you have the title and a death certificate, you would be able to transfer the title from the deceased spouse into the surviving spouse's name. So you wouldn't have to worry about that. So if when you're reviewing your assets, everything would be jointly owned except for the vehicles, then you would be in a situation where not a big deal. You would just want to make sure that as the surviving spouse, you have a death certificate and the title, and you would just transfer it into your name. That would be how you would handle that. As far as personal property goes, we have some clients that do like to have certain items, guns, jewelry, certain things go to individuals other than their spouse when they pass away. So, what I would tell clients to do is if that's a situation where you don't want it to go to the spouse, you want it to go to maybe children, just remember that in Pennsylvania there is an inheritance tax. So, if you set up your estate plan like that, then there will be tax based on the rate of that category of individuals. So if it goes to direct lineal descendants, for example, they pay 4.5%, siblings pay 12%, everybody else pays 15%. So if you have certain items that would be going to your children and not to your surviving spouse, just know that there would be inheritance tax that would have to be paid. If everything is going to the surviving spouse, the beauty of that is that if you have beneficiary designations or it's jointly owned, there would be no tax and there would be no probate that has to happen. So best tip that I can give you today is just confirm the titling of assets to make sure that you don't have a situation where there's an account or an asset out there that's just in one spouse's name, because you will have to administer an estate in order to be able to transfer that. The other question I get between spouses has to do with credit card debt. We have some clients where one spouse had a credit card and might have incurred some credit card expenses. Sometimes we even have it where the surviving spouse didn't realize that there were these charges or these credit card expenses. So we get questions a lot about that, about does the surviving spouse need to pay the credit card expenses? And the important thing to know about that is first is who's on the credit card account. So if it's just in the deceased spouse's name, that's one thing. But if you are a joint owner on the account or a joint signer on the account, you're going to be responsible for that debt regardless of whether or not you knew about the charges. If, however, it's just in the deceased spouse's name, so let's say we have a husband and wife, a husband had a credit card, had charges on that card, wife didn't know about it, wasn't on the card, didn't sign for anything, and the assets are all jointly owned or have a beneficiary designation. The reality of that situation is it's going to be very difficult for the credit card company to be able to recover any fees or any payment from the estate, because nothing goes through the estate. Even if you have a will, if the asset is jointly titled between husband and wife, or if it's an IRA, for example, that has a beneficiary designation going to the wife or to the spouse, then their credit card company can't recover against the probate estate, and that's where they can get funds. So the other thing that I would make sure is that jointly owned assets or assets with a beneficiary designation can be really important when we're talking about having to pay off debt when one spouse dies. So that can be really important there. So just make sure that you know who's on the credit card accounts. You make sure that you are understanding what debt will have to be paid back when one person dies based on how assets are titled. The other thing that I get questions about has to do with prepaid funeral when it comes to husband and wife. So I recommend, there are two ways you can do it. You can either do a prepaid, go into the funeral home, for example, and prepay it with the actual funeral home and set aside funds there, or you can assign your life insurance policy to the funeral home, or you can go through the process of getting an irrevocable burial CD, and I recommend that each spouse has that. That way, if one person dies, one spouse dies, there are funds there to pay funeral expenses. The other question that I get is when one spouse dies, how many death certificates do I need? Because usually you want to order them within the first month or so through the funeral home, because if you wait too long, you have to get death certificates through the state. So the question that I sometimes get is how many death certificates do I need to get? When you're talking about a situation with a husband and wife, and again, we have everything jointly owned or has a designation, you may not need to order many death certificates. The reason why is that the rule of thumb is that you need a death certificate, an original death certificate, for every institution that you're going to have to administer the estate for. So for example, if husband and wife had separately titled assets at the bank, they had separate titled assets with their investment broker, then they would need a death certificate for each institution, meaning they need one for the bank and they need one for that financial firm where they have their investments. You also need an original death certificate for titles of vehicles that you need to transfer. So if we have title in husband's name and he dies, not a big deal, but we do need the death certificate and a title to be able to transfer it to wife. So if you have multiple vehicles, just know that you're going to need a death certificate for each vehicle. Now, the only exception to that is that you can get a form. Typically, the funeral home can help with that. That would allow you to transfer title. And typically, you don't need a death certificate for that. So you want to count up how many institutions you're going to have to administer the estate for, and then get a death certificate per institution. If you have several accounts at one institution, typically you don't need to send more than one death certificate. And again, if it's something where it's beneficiary designations and jointly titled assets don't require a death certificate. Beneficiary designations, typically they would, so you would get a death certificate for that institution. So I hope that helps a little bit as far as when you're trying to count up how many death certificates you need, and gives you some tips there. But if you are a surviving spouse and you do have questions, you can always feel free to call our office. We always try to go through situations in which a spouse does need to be appointed as the executor and administer the estate. But most of the time, especially for our clients that have done wills, they really don't have to do anything. There's no tax. They don't have to file an inheritance tax return, and assets are jointly owned. So title just vests in the surviving spouse, or there's a beneficiary designation, so you fill out the claim form, submit it to the company, and get your funds. The last question I wanted to talk about is that I'm getting more and more clients coming in that ask about a joint will. We don't do joint wills at our office. We do a will per individual, because if it's a joint will, then the question is if we had an asset just in husband's name and he died and it's a joint will, how do you handle that? So we have a will for husband, a will for wife. When one of them passes away, if there are assets that are individually owned, then their will would distribute those assets. The executor appointed document would be the one that's going to administer the estate. Now, that being said, most of the time husbands and wives have wills that are mirror images of each other, because that way it doesn't matter who passes away first. We can make sure that the terms align with what you would want. We typically represent husband and wife together as a couple. So we don't want to have separate provisions, because then it's whoever's the last spouse to survive, or the last spouse living, the last man standing. That's how the estate gets divided. So typically we have one will for husband, one will for wife, but they have mirror images of each other. If anybody has any questions about the estate administration process, especially in this case, in this example where you're a surviving spouse, you're always welcome to give our office a call. You can call us at 717-655-2676, and we'd be happy to answer questions. The first thing we try to do right off the bat is determine whether or not we're going to have to probate, or whether assets are jointly owned or have a beneficiary designation, and maybe we can avoid probate. So that's usually the first thing that we help our clients figure out. Again, remember, jointly owned assets, assets with a beneficiary designation, we don't have to worry about that when the first spouse dies. So that would be my recommendation as far as that goes. I am Samantha with the law offices of Samantha Wolfe, and this was our most recent virtual seminar talking about when one spouse dies, what do you need to do to administer the estate? If you have questions, concerns, we have consultations, you're welcome to reach out to our office. If you want to watch more videos, check out our YouTube channel and tune in for our monthly virtual seminars. Thanks, everybody.